for being here. My name is Felipe. I'm a PhD student in sociology at the University of Warwick. I'm trained as a lawyer for my undergrad, and I'm working on the expansion of intellectual property. And in the context of that research, I become very much interested in the effects that the interactions between disciplines have had on the Anglo-American legal culture. In particular, I've been interested in law and economics. And whenever you're reading about law and economics, in the last 20 years, you're more likely to find that there's a huge controversy on whether law and economics is an example of what is being called economics imperialism. As you will see, I'm kind of skeptical about this whole narrative of imperialism. I think that the picture is way more complicated than that. Obviously, this always is. And so I'm going to talk to you about that. So by a quick raise of hands, how many of you are trained mainly in economics? Okay, the least of you. That's interesting. So the others are lawyers, social science people, and whatnot. Okay, I will just assume that everyone else is kind of in social sciences and law. And so the first I'm going to speak a little bit about imperialism, and I'm going to offer a more nuanced perspective on how to understand disciplinary interactions. Because I think that this, as I was saying, this narrative of imperialism is way too much one-sided and is very coarse to really get the details of the patterns of disciplinary interactions between law and economics. The law and economics have a long and fairly complex history of interaction. And so we're going to be talking about that. I'm going to discuss how the boundaries between law and economics have changed, and in particular I'm going to talk about formalism, both in law and economics, and the effects that formalism has had in the pattern of disciplinary interaction between the two disciplines. And then I'm going to frame that debate, or the debate about disciplinary imperialism, as a case of reductionism and anti-reductionism, which will be clear when we get to that part of the presentation. And then I'm going to present some theoretical consequences that should follow if my framework is sound to you. In particular, I think that, especially for those of you that are in economics or are planning to work in economics, I think that the moral or the main lesson that you should take away when you're leading this lecture in order for me to be successful would be you to be mindful about the implied assumptions that you brought into your analysis when you use theoretical frameworks for other disciplines. In this case, we're talking about law, but I think that the very same case would apply for sociology, political science, anthropology. Whenever you're discussing or you're trying to provide an economic explanation about a social phenomena, you're most likely, if you're not aware of it, you're going to introduce some assumptions without realizing it, unless you're critical about the framework that you're adopting. I think I'm going to argue that this will be the case of the bundle theory of rights. The bundle theory of rights, right there. And so I'm going to start. So, a brief definition of disciplinary imperialism. You look at this definition and you think, okay, makes sense. So you have this field, law. It's been traditionally the turf, if you want, of lawyers and legal theorists. And at some point of the 20th century, you get the Chicago School of Economics, and you get Ronald Coase, and you get Richard Posner, and Guido Calabresi, and the rest of them, and they sort of kind of say, we can do this better than you, and so we're going to take over, right? So that's more or less the basic disciplinary imperialism narrative that I'm trying to debunk or to show that it's incomplete. And so, if you can read with me, I'm just going to read these two quotes that you have on your handout to see the different attitudes towards disciplines that are in play or that are in competition. So, and the historical context of these two quotes is important because this is in the late 70s, early 80s, the moment in which law and economics was at its height. In terms of theoretical power, it was expanding. Judges that were starting to accept economic reasoning or include economic reasoning within their decisions. And it's the moment in which this literature exploded. And so, first, from the legal perspective, much of the work that we, this is legal scholars, have settled into can be done as well, if not better, by sociologists, economists, political scientists, and many others. When I ask myself what we have to contribute that is unique, the task I return to all have at their basis our special familiarity with the legal language. And now Coase. The success of economists in moving into the other social sciences is a sign that they possess certain advantages in handling the problems of those disciplines. One is, I believe, that they study the economic system as a unified interdependent system and therefore are more likely to uncover the basic interrelationships within a social system that is someone less accustomed to looking at the working of a system as a whole. Another is that the study of economics makes it difficult to ignore factors which are clearly important and which play a part in all social systems. Such a factor would be that, to a large extent, people choose their occupations on the basis of money incomes. Another would be that a higher price lowers the demand. Such factors may appear in various guises, but an economist is likely to see through them. And so, what I'm going to argue is that the controversy between legal theorists and economists is a controversy about the usefulness of legal language to explain legal phenomena. So on the lawyer's side, or the basic assumption of lawyers is that legal categories carry meaning, as with economists would say that they're basically just name tags for different sets of incentive structures. I think that there's some truth to both assertions, but this is basically the two basic attitudes that are in play and that we're going to see developing throughout this presentation. And so, before we go into, or before we start building a more effective or a better model of disciplinary imperialism, we need to think about the role, the epistemic role that disciplinary boundaries play in knowledge production, right? So here you can sort of see two poles, again, two different sets of attitudes or belief that one can take with regards to disciplinary boundaries. So the idea is that you can be either skeptic about disciplinary boundaries, and in that case you tend to favor movements or you tend to favor the eroding and the elimination of disciplinary boundaries. So, for instance, you would say, well, the task of science, for instance, would be to explain all reality at a fundamental level. So you would reduce biology to chemistry, chemistry to physics, physics to fundamental particles, and so forth. And the idea is that you gain knowledge as you develop a unitary language to express all theoretical phenomena. On the other side of the spectrum, you have the notion that there's a division of labor happening between disciplines. So different disciplines are better suited or have developed throughout the revolution, have developed a theoretical framework that allows them to deal with the phenomena in a specific way. So on this side, then, if you're thinking that, or if your intuition is that disciplinary boundaries help produce knowledge or help in the process of knowledge production, you would be fairly on the side of those people that said that there's a certain core or there's a proper domain for each discipline, which cannot be reduced to the theoretical framework of another discipline without losing some knowledge, some relevant knowledge. Let's say in the case of rational choice theory, you have an economist and a psychologist. The psychologist will say, well, your concept of you cannot reduce everything to preferences because there are other mechanisms, psychological mechanisms that help explain human action. And so the economist will say back, well, we can try to, and we can better, we can build more complex models, but eventually we should aim at having only one framework from which to explain human action, instead of having sort of different disciplines dealing with different aspects of human action. Okay? It's the same with law. So legal categories in this case would have a specific rationality that cannot be reduced to economic rationality or to an economic explanation. And the economists in turn would say, well, let's see, let me try to, I think that knowledge is gained by trying to reduce legal knowledge, so to speak, to economic knowledge. And so, imagine now, and you have a description of each of one of these tags that I invented, or these names for different possibilities of disciplinary interactions. So imagine that you have, it's a simple model, you have two disciplines, each one has a mainstream and a core in which a dominant school, if you want, and a fringe of other sort of practitioners. And so when I'm talking about the original discipline and the host discipline, I'm talking about the mainstream, right? So you can either have one discipline, for instance, rejecting the move, and the original discipline accepting the move. And so, for instance, original discipline accepts the move. I think that I inverted them, so it doesn't matter. In the case of heretical imperialism, the idea is that the discipline that's making the expansion, you have a research group or a team of scholars developing a research program, and they go into the turf of a different discipline. The host discipline, right, accepts the move and not rejects, as in this case. This should be like this, while the original discipline rejects it. And so in that case, let's say you have a team of rogue economists and they go to explain some area of that corresponds to another discipline, and the mainstream of economics says those guys are crazy, they're not doing economics, this is not a fruitful research avenue, etc. And so they get cut off eventually, and they move towards the host discipline. So they become practitioners of the discipline that they were trying to explain. So a good example would be economic anthropology. People like Calabresi, that many people would say that started off as an economist but then drifted towards more anthropological, and by the end what he was doing was nothing unlike the mainstream of economics at the time that he was doing it. Then, in the second case, in the case of traditional imperialism, the original discipline accepts the move while the host discipline rejects it. And so in that case, we would have what we would call traditional imperialism. If the expansive move by this research team, this hypothetical research team that is trying to conquer, notes all these sort of territorial metaphors and political metaphors that are in place here. This is a problem of talking about imperialism, that you start with a base assumption that there's something wrong with it, or that the burden of proof is on those who want to alter the discipline. In the case of traditional imperialism, if the movement is successful, then you have a retreat of the original discipline. Basically, the practitioners eventually will lose their epistemic authority, their knowledge claims will not be as valid as the ones from the competing discipline, and then so their domain of expertise, if you want, will shrunk, and they will retreat to a position in which the theoretical framework of the quote unquote invading discipline is yet not appropriate to explain the remaining phenomena. If both disciplines accept the movement, the expansionary movement, then you have a case of scientific unification, right? Should have thought about some examples, but well, you may think. Well, we'll see an example of unification in the development of law and economics afterwards. But then, finally, if you have a failed research program, which is both, again, this is upside down, I'm sorry for that. If both disciplines reject the move, it's a failed research program. The effect of a failed research program could be the strengthening of the boundaries between disciplines, meaning that that research avenue, that research program is discredited, and so people say, okay, you do your thing, I'll do mine, and let's not be mixed again. Let's go separate ways, right? And so, one further aspect before we can really start talking about law and economics, which is probably why you're here, right? There's two ways of studying disciplines that corresponds to two aspects of what disciplines are. First, you can study disciplines from the standpoint of the way in which they're organized. So you would go to see, in the case of law, you would see law schools, legal journals, professional associations, tenure track patterns, the interplay between lawyers and the public sector, etc., etc. right? This is an organizational or perspective. It's basically seeing academic disciplines as a practice, basically bounded human beings in a context doing stuff. And you can also see disciplines from the standpoint of the kind of knowledge that is produced by those very practitioners, right? And this would be this would correspond to disciplines as a form of rationality, or a way in which the practitioners of that discipline think. In the case of, for instance, economists, you will quickly start to think about, oh, yeah, there's a very distinctive way in which economists tend to think, right? That more or less corresponds, in the mainstream, at least, to what Coase was saying. So basically, facing a certain social phenomena and seeing, well, what are the incentives behind this? What are the economic consequences of this legal arrangement, of this institutional arrangement, of this social arrangement? How are they altering behavior, etc.? And the best example that you can get actually is, I don't know if you read it, Stephen Levitt's Freakonomics. Stephen Levitt is sort of like a follower of Gary Becker, which is the most extreme form of this economics imperialism. He basically claims that the framework that economists use, or the framework of neoclassical economics, can be used to explain any kind of social phenomenon. So he has books on marriage, abortion, on crime, etc. Anything under the sun could be explained by this economics. So the idea is that you have to keep in mind is that you can have these two aspects of disciplines. Now, let's go to law and economics. What I will argue is that formalist trends between in both law and economics during the 20th century, and that pattern of or that shift towards formalism changed the relationship between law and economics. Law and economics, up till the second half of the 20th century, had a long history of sort of disciplinary interaction that was more or less a relationship of unification. But then, with the advent of neoclassical economics and legal positivism, that changed. Let me explain you why. So, when I'm talking about formalist trends in law and economics, what I mean is that there are certain analogies in the way in which both disciplines evolve that are to bear in mind, because basically it was the dominance of the systematic and the aspect or the systematic approach to legal phenomena and of formalism in the case of economics that created, that is behind or is underlying the framework of law and economics. Likewise, at some point, there was what I'm calling a practical approach to the study of legal phenomena that corresponded to realism in economics. That, in the case of a concrete sort of economical school, would be the German School of Economics of the 19th century, and then it's here in American scholarship, American institutionalism. And so I'm going to do a very sort of quick sift through the history of legal theory, about 200 years in 2 minutes. So you can see both the systematic and the practical approaches already in common law classic theory. The basic idea of common law theory is that you have certain principles that can be discovered through reason, which all humans have, but also have an historical character. Common law evolves with time, and this evolution is captured by it's pushed forward by the judge's decisions, by precedents, right? So this this interaction between these two approaches to the study of law are what pushed or what generated Bentham's original critique against common law theory, because Bentham was thinking, okay, so the issue is that legal principles are indeterminate, so they leave a certain leeway, or they give judges, unappointed judges, a space to decide whatever they want, basically. So Bentham did not buy the idea that judges were using the reason to discover the sort of hidden rationality of common law basic principles. He was saying, no, these guys are making law, and so if we're gonna have people making law, we should have people with democratic accountability making law. So we should have the legislators. But the issue is that if the legislator is going to make law, it has to make law in a clear fashion. And so Bentham's theory of utilitarianism is Bentham's approach to the improvement of legal language. The idea is that once that we have a clear language on which everyone can access, this is the idea of the principle of utility. So anyone can understand the principle of utility, and Bentham thought that you could actually objectively measure welfare satisfaction, and you could measure happiness, let's say. So eventually everyone would be able to see what the consequences of legal decision were. So instead of justifying a legal decision on the false claim that it was representing the immanent rationality of common law principles, Bentham was saying, no, we need a clear language that people can understand and can say, okay, so this will be the consequences of having this, of making this decision. So John Austin continued in the 19th century, continued Bentham's project of sort of reforming legal scholarship, of attacking the classical theory of common law, but he made a small twist. He also believed that a clear language was necessary for better understanding law, but he thought that the study of law should be carried through the study of the concepts that are universally necessary. Let's say duty, right, sovereignty, etc. These kinds of fundamental legal concepts that you will find in any modern legal system. So if you find, and if you can define those in a clear analytical fashion, then you won't have the problem of indeterminacy that Bentham was talking about. The issue is that Austin thought that this did not imply that the decisions that the judges made were illegitimate or should not be part of common law. He had no issue with judge-made law, and if done under the sort of theoretical definitions that he was making. In the 20th century, this Austin's framework was taken by the American legal realists, and they were against it. Was taken by the mainstream sort of was taken by the legal formalists or classical analytical jurisprudence, as it was called. And American legal realism was was a reaction against it. So the basic idea is that a lawyer and a legal theorist should be capable of predicting legal outcomes. So the problem now, again, with indeterminacy, or the idea that legal materials or legal sources underdetermine the judge's decisions, was for the legal realist to be completed with the help of social sciences. So famously, Justice Holmes, in a famous address to the, I think it was to the American Bar Association, was talking about the future of what the future of legal theory should be, and he says the lawyer of the future is a man of economics. He should know statistics. Obviously, he said a man because he didn't thought that women could do stuff. But if he would be more sensitive, he would say that men and women in the future, lawyers will should take the insights of economics and other social sciences and bring it into legal scholarship in order to make predictions that are accurate. He said, when someone wants to understand how a legal system is working, it is of no use to simply understand the doctrines and the principles of any branch of law if he doesn't know how it actually works in action. There was the American legal realists, they had this distinction, which is more or less a caricature, but it works for didactic reasons, of law in action, or between law in action and law in books. So the idea is that you need to understand law as a practice, how it works in the real world, not just so, or basically, you need to see not only how lawyers think or judges think, but you need to understand how they actually behave, how they actually decide things, not how they say that they're doing it. Now, this was a dominant approach to legal theory in the US during most of the 20th century up to the 60s or so. And then during the second half of the 20th century you have Hart. Basically, Hart, what he did was, for those of you that know some sociology, he sort of rehabilitated through an adaptation of Wittgenstein's language theory, the idea that if you want to understand a social practice, you need to understand the internal point of view, which means that you need to understand the frame of mind, or you need to understand the theoretical framework of those who are inside the practice. To give you an example, if you want to understand what rules are, you need to understand what rules mean, or following rules means to a legal subject, or to someone that is tasked with applying that rule. And so this means that to really understand any legal system, you need to understand the framework, the conceptual framework that is that the agents that operate that system use. So you have a more or less similar development from the 18th century to the 20th century in the case of economics. So, as in the case of classic common law theory, you have two approaches to classical political economy, one based on moral philosophy, which is basically deductive. The idea is that humans have certain features to them. For instance, they like to barter, they're pursuing happiness, etc. And so starting from those basic assumptions about the rationality of agents, you can then discover the principles that underlie the economic order. The other approach was based on natural history, and it was based on the idea that you should have and you should go and investigate actually how this was happening in reality. So the formalist approach became dominant in the 80s, 70s with the marginalist or the marginal revolution, which was basically the idea that starting from some basic assumptions about how a subjective value was formed, you could then sort of flesh out a set of consequences for the workings of markets. That approach was followed by then again a more practical or a more realist, if you want, approach to economics, but that sort of deflated with the advent of the Chicago School of Economics and the end of what has been called the end of pluralism in economics. At this point, American institutionalism interacted heavily with American legal realism. These guys are the ones that are behind early antitrust doctrines, the creation of the welfare state. So they worked at the same universities. They use many of the same. They use the same theoretical framework for some of the stuff that they were doing, and at that point, the pattern was very much a pattern of disciplinary unification, because as a legal realist, we're saying we need the methods of social sciences to issue better predictions. The institutionalists were saying we need to understand how institutions work in order to provide an accurate picture of how the economy is functioning. Now, the bundle theory of rights. I'm gonna go very quickly on this because it's so. The bundle theory of rights is it's a framework to understand any legal institution that was developed by at the beginning of the 20th century, in the late 20s, by Lee Hale, who died very young but managed to get this in, which is one of the most cited papers in the history of law and also in economics. So the idea is very basic. You have sets of opposites and correlatives, which means opposites. If you have a right, then you cannot have a no-right. The opposite of a right is a no-right. This, the opposite of a privilege or a freedom, we would say, is a duty. And let's forget about this side because we're not getting into that. And the correlatives are the position that another agent is with respect to you. So if I have a right, then someone else has a duty with respect to that right, and the same. If I have a privilege to do something, for instance, the other person has not a right for me to not do that. So if A has a claim, then A lacks no claim, and here, if A has a claim, then some other person B has a duty, and so forth. So if I have a privilege, then the other person lacks a right or a claim, if I have a power, and that. The important thing about this is that Ronald Coase used it, this is the framework or the approach towards right that was implied in Ronald Coase's social cost paper, or his theorem about transaction costs. So the importance of that is that you can basically take or separate property into a bundle of use rights. So for those of you that are economists, this should be very intuitive. The idea is that any valuable attribute of any asset to has as a legal reflection, if you want, a use right, which means the right to use a thing. So if I have a car, for instance, it would be the right to use my car. So if I have a right to use my car, then you have a duty not to prevent me from using my car or not interfering with me using my car. Now, any of these use rights can be traded through contracts. So this is the model, the basic model that Coase was assuming. Now, the important thing is, given the fact that all allocations of use rights, which means that any possible use of an asset has economic value, because if I have a cell phone, but I can only, take pictures with it, and then I cannot make calls with it, the value of the phone is lower. If that is true, then basically anything can come under the expertise of economics, because any allocation of use rights will have economic effects and therefore should be understood in terms of economics. As a corollary of that, legal categories don't make sense. In the end, all that is important is what are the use rights and what is the institutional means on which you're going to use to protect them. At the same time, the bundle theory of rights needs a definition of what counts as an interference. So if you go back here, so let's say I have a right to use my car, and so that means that some other person B has a duty not to interfere with me using my car. But the issue is, I cannot know what counts as an interference only of driving, let's say, only by knowing what driving is. So you need an additional sort of criterion to define interference. And this is precisely what the notion of externality in economics provides. I'm using a sort of general definition that an externality is any event produced by an agent that alters another agent's cost structure in performing the action. And so now it should be more or less clear that the debate about economics imperialism can be restated or can be seen through the lenses of reductionism and anti-reductionism. And so here is the last quote. This is by a legal scholar. So he says, the debate between the corrective justice theories, which are basically defending the validity of legal categories, and the economists, raises a more purely jurisprudential question about what legal theories must do to be acceptable. For while economists are boasting about their ability to explain away the plaintiff-driven nature of tort law in a reductive manner, corrective justice theories are stating that a theory that merely explains away structural features of the law in a reductive manner is for that very reason inadequate. So, basically the idea is that lawyers or legal theorists, in order to protect the autonomy of law as a discipline, are desperately trying to find certain irreducible features of legal arrangements that cannot be understood in terms of prices and incentives, or that cannot be approached to the bundle of rights theory. This is why actually legal formalists have started to reject this approach to rights and have tried to provide alternative explanations of what property is. And so, but my doubt here starts because, so what's wrong with reductionism in principle? The idea that you can have a sort of external standard for evaluation that everyone can assess, and thus you can increase the testability of knowledge claims, seems to me to be, in principle, fairly reasonable. I mean, basically what economists are saying is that, well, I can say that tort law, for instance, is a mechanism for distributing the cost of accidents. We can discuss about it, but the idea that this is reductionist and is illegitimate per se, it strikes me as okay. Just